Вітаємо вас, пані Тетяна.
Welcome, Tetiana, at the second stage of their selection to the High Qualification Commission of Judges of Ukraine. The interview is conducted by the Selection Commission in its full composition: Stephen Markman, me, Ivan Mishchenko, Serhiy Verlanov, Robert Brookhuizen, Ted Zazhachny, and Yevhen Mezentsev. The reporters at your interview are Stephen Markman and Serhiy Verlanov. In case our interview is interrupted for some technical reasons, we will reappoint it, reschedule it. But let's hope that this will not happen. Tetiana, the members of the Commission will keep asking you questions, and please, the request is that you give concise answers to the core of the matter, and the member asking the question can limit the time of your answer. And before the Q&A session, you will have a chance to present yourself, to tell about your motivation for the participation in the selection. And now let me give the floor to my colleagues, Stephen, Serhiy, you're welcome.
Thank you, Mr. Chairman. Thank you, Tetiana. Thank you, Ms. Slutska, for participating. Would you like to speak for several minutes and just give us a little bit of background on your motivations and your interest in participating in this competition?
Good afternoon, dear commissioners. I'm Tetiana Slutska, PhD in law. I've got 2 children. One of the children is now defending our state, being in the armed forces of Ukraine. As far as myself is concerned, let me tell that my professional record, my professional experience is 20 years, and 12 out of these 20 years are the years when I have been holding top positions in cassation courts. Over this period of time, I participated in the development of the constitutional motion on the official interpretation of some provisions of of the Code of Criminal Procedure of 1960 and some provisions of the law of administrative procedure in the context of Article 55. I was also authorized by the plenum of the High Specialist Court to present this motion in the Constitutional Court, and I was one of the regular development of the information letters and recommendations for judges of trial instance and appellate instance in the issues that were related to application of law in terms of the Code of Criminal Procedure of 1960 and substantive law. In particular, I was one of the developers of the information letters that were related to adoption of the laws on amnesty in 2011, 2014, and that was also related to the law on amending certain legislative acts of Ukraine due to humanization of responsibility for offenses in the field of commercial activity. Also, I'm a developer of the resolution of the plenum of the High Specialized Court of Ukraine on the practice of doing criminal proceedings under agreements. I participated in a number of task forces and international projects. In 2012, in particular, I was a teacher at the National School of Judges of Ukraine in Kyiv and in different regions of Ukraine, and I was the responsible secretary of the Scientific and Practical Legal Journal, the Court Practice in Criminal Cases, and a member of the editorial board of the official printed edition of the High Specialist Court of Ukraine for criminal and civil matters. And I am the author of several methodological manuals for judges. My motivation for applying for this competition are grounded on my vision of the future of the judiciary. And this vision is as follows. The judiciary must meet the highest international standards and hold the proper place within this three-branch system of power is the guarantee of stability and reliable protection of human rights and freedoms. And it should be the system that has proven that it is reliable and that you can trust it. Thank you.
Ms. Slutska, I think I was derelict in not introducing you in a little more detail. Let me quickly do that, if I might. You have a very impressive background, and I think it should be highlighted, and I should have done it already. You've been a professor of law for 7 years. You've been a consultant assistant at the High Specialized Civil and Criminal Court of Ukraine for 7 years. You've been part of the Secretariat of the Supreme Court of Ukraine for 5 years. You have a son and a daughter, and I believe your son, as you mentioned, is now serving the armed forces in defense of Ukraine. And you've been very active in terms of a pen and pencil. You have edited publications such as Criminal Proceedings and the Journal of Civil and Criminal Proceedings. You've written judicial manuals. You have a personal blog. I'm told it's very good by my colleagues who are better able to read it than I am. And you've contributed a number of articles to the Great Ukraine Law Encyclopedia, which I've not yet completely finished, but I'm impressed by the subjects that you've written on and the variety of those subjects. Let me ask you a few questions, if I might, please, to start off things. According to one civil society organization, Ms. Slutska, there was a citizen by the name of Vladislav Sergeyevich Slutsky who donated 298,000 hryvnia to the election fund of presidential candidate Sergei Taruta in 2019. Is it possible that that was your son who made that contribution?
No, it's not possible that this is my son who did it, and let me explain why. When I got access to this file and saw this information, I was actually shocked. And my son was shocked when I asked him about the fact whether he had given his personal data to anyone. If we open the data the civil society points to as analyzed by it, we can see that it is in the form of a table. And as I think, this data is not a sample of a reporting document, and there is no specific identity data, either passport data or identity code, for it to be clear that the data of my son was used for this purpose. And if we analyze it in terms of the information provided there, it is indicated that 129 people actually gave donations to this candidate, and most of them are the residents of the town of Boryspil. And on one and the same day, in fact, they gave the same amount of money, 298,000, to this candidate, to this man. This fact actually confirms the statement, which is also used by the civil society organization Chesno, referring to the fact that there was a journalist investigation in relation to another candidate from the same party, and it was clarified that some personal data of people was used, and the people didn't know that they were donating money, and they couldn't be the donators because of the lack of financial resources for that. And besides that, let me add that my son was not employed. He was 19 back then. And even if we assume that he had, by some chance, 298,000. A 19-year-old boy who doesn't have his own car or his own apartment or house, and if he has that amount of money, 298,000 hryvnias, well, you may just imagine how doubtful it is that he would donate this money to someone. Besides that, this amount, or a little bit larger sum, is actually my salary for half a year, if we take that period of time. So either physically or technically, this could have been done. This can actually show us that his personal data probably was used, but we cannot know about that from this information. So this just proves that his personal data was most probably used in the wrong way by some other people who have something to do with this election process of this candidate.
And just to be clear, Ms. Slutska, you have spoken to your son about this, and he denies that this is a contribution that he made.
Well, I didn't even ask him whether he had this amount of money, because I didn't have doubt that he didn't have that amount of money. I just asked him whether he gave his personal data to anyone for this data to be used. And he said that no, he didn't give any personal data of his to anyone, and he said that he wouldn't ever have done this. Okay. And unfortunately, now he cannot make official correspondence to make an inquiry concerning identification of his personal identity, because he's in the army.
Okay. Well, thank you very much. Ms. Slutska, you're a co-founder of Dobrosud, as you know, not telling you anything you don't know. And after less than a year in a leadership position there, I understand you terminated your involvement totally with the board of Dobrosud and withdrew from membership of the organization. Can you explain just very briefly what Dobrosud's mission was and why you left it so quickly?
So why I withdrew, and when I stopped being a member of this association and the member of its management board. And the reason was very simple. Back in 2019, when there was a law adopted on the establishment of the new HQCJ following new principles and new rules, I also submitted my documents. I applied, but on the basis of the decision of the Constitutional Court, this process does not take place. When we established this NGO, Dobrosud, there was no law yet. I mean that there was no law under which we are now holding this interview in a way, or we have this selection process. But after it was adopted in July, and in August it came into effect, then since I understood that it is the NGO and judicial candidates are there, and some judges who will be taking qualification assessment, are members of it. So I just left this organization, and I was supported by my colleagues in that, because I wanted to avoid this kind of conflict of interest. And the mission of this organization was, and actually is, though it's not fully implementable as for now, is to raise the level of trust of citizens in the judiciaries through actions, through conduct. And, you know, now we have a lot of negative things in place, negative perception of the judiciary, of the judicial branch of power. But we should mention that not all judges are bad and have a bad perception. There are a lot of good judges who are holding this position and are actually meet the requirements for it. So to show this positive image, to create this positive image, to work further on with the people with whom you need to work to raise this level of trust and to improve this perception and image of the judiciary in the society. Well, that was the goal why we established this organization. And I think that after the war, this association will play quite an important role, and its activity will be fully implementable because the objectives of this NGO are rather high. They are highly in demand both among the judiciary and in the society.
Ms. Slutska, in your motivation response, you refer on a number of occasions to a term that you call the principle of legality. I'm not completely sure what that means. Is that the same thing as the rule of law, or does it mean something distinctive? Can I ask you please to respond, if you can, fairly concisely, but what do you mean by that? I haven't heard that concept expressed exactly that way.
In my motivation letter, in item 1, paragraph 1, I mentioned the principle of legality should be enshrined not only in the law, but it should also be a principle which is kind of an idea that reflects law in action, law in effect, application of law and implementation of law. I think, and this is also confirmed by the decisions of the European Court, in particular in paragraph 41 of the report of the Venice Commission, that the principle of legality or legitimacy is one of the main elements of the rule of law.
But how would you define, Ms. Slutska? I'm sorry to interrupt you. We need to move on, but I still don't understand what the principle itself means. I understand you believe it's incorporated in European law in some respect, but I haven't heard that term used. What is the principle of legality? What does it stand for?
Що він означає? Well, for me, the principle of legality is a very broad notion. If we speak about the timeline, which is set by the law, so the principle of legality here is should be complied with to the full. If we refer to application of law, under the law of Code of Criminal Procedure, Article 8 presupposes rule of law, while Article 9 presupposes legality. So the notion of legality or legitimacy is rather well developed there. And legality presupposes that international treaties ratified by the Verkhovna Rada of Ukraine are a part of the law of Ukraine, the part of our legislation. So by compliance with the law, we mean law in broad terms. And if the principles, the provisions of the Code of Criminal Procedure in some part do not meet the international treaty norms, then the norms of the international treaty should be applicable. Also, if the norms of the procedural law do not regulate a certain issue, then we have to apply the principles of criminal law, the general principle of criminal law. That's what it is for me.
Okay, thank you very much, Ms. Slutska. Let me move to my co-rapporteur, Judge Sergey Verlanov.
Thank you, Stephen. Good afternoon, Tetiana. I will have the following question to you. We can see it from your CV that your overall work experience is more than 20 years as for now. Over the period of your work in different bodies, as we can see from your documents, you have probably participated in some selection and assessment of the candidates in the bodies where you worked, or no? When I worked in the High Specialist Court of Ukraine, I really had to face some selection processes. I mean, it's not selection, but this was probation Some people were to be selected on the basis of probation to become my subordinates. And the law on civil service presupposes that every year I have to make assessment of my staff. And when I was being transferred from High Specialist Court to the Cassation Court of Ukraine and to the Supreme Court, I also had to hold interviews with staff members in order to determine whether they are suitable, fit for this position. I'm demanding to myself and also to the staff I work with. Clear, thank you for the answer. Could you please tell me what the criteria for assessment of these candidates were? As far as the criteria are concerned, so first of all, it was all about professional competence because of the specificity of our work. So professional competence, the first thing, and also of importance for me is integrity of a certain person. During the interview, I asked questions that helped me to determine predisposition of a person to some abuse of power. And now I can really vouch for all my staff members. So this means that you were trying to focus on the integrity criteria and to prevent abuse of power. Did you check any other criteria? Well, if we speak about the declaration, I didn't have access to the declaration because only HR department could check the financial status of candidates. But nevertheless, I asked some questions and I saw what the way of living of these people was. And if I had any doubts, I did not hire this person. I did not select this candidate. So if you selected some criteria and then you selected some people on the basis of them. So didn't you make any mistakes? I never made a mistake. I mean, I was never sorry for the choice I had made. In terms of the staff I selected for my structural unit. Okay, Tetiana, please, this is quite a provocative question, but since we are to select the members of the HQCJ, we need to hear your idea about your suitability, your eligibility for the position of the member of the HQCJ. So could you please tell us why should the selection commission think that you are a decent, a good candidate for being a member of the HQCJ? I consider that I'm a person of integrity and I can actually confirm my integrity. And what are the manifestations of this integrity? The manifestations, I'm honest, I'm impartial and unbiased. It's not possible to exert any pressure on me. I'm a person of principle, maybe sometimes even too much. My income corresponds to my way of living and to my property status. Well, that's it. And I'm diligent in performance of my duties. I told in my motivation letter that what I did, what I managed to do, what my achievements are, and this was done over the periods of my work in the High Specialized Court. That was the transition period when the Code of Criminal Procedure of 1960 and 20 was transformed into the Code of 2012, and this new code contains some names of institutions that were not known to anybody either in theory or in practice. And this transformation shows me that I can really work around the clock and 24/7. And I think that that's the way you will have to work as a member of the HQCJ, even to the detriment of your own life. Well, I wouldn't say life and health, but to the detriment of your personal, private life. Because I actually don't just work. I get pleasure from my work, which means that I live here. I derive pleasure from getting a good outcome. I want to be useful for the society. And when I see the result, I still get inspired, get enthusiastic and energetic about this outcome, and this urges me to act further on. Okay, thank you. Keep on doing that. And here is another question, Tetiana. In paragraph 8 of your motivation letter, you suggest introducing changes into the current applicable regulation of the HQCJ to make it more in conformity with the applicable legislation. Please concisely explain what is the discrepancy between the regulation of the HQCJ and the current applicable legislation, because it's just a general phrase. So what do you mean by that? I made just a general statement for many reasons, because I thought that the motivation letter can be published, so I would not like to give prompts to other candidates for this position. But as far as the regulation of the HQCJ is concerned, first of all, it does not take into account the composition of the HQCJ that we will have, and there are some discrepancies concerning who has to hold the first meeting, if there is no chairperson and deputy chairperson, who and when is supposed to hold the first meeting of the HQCJ. So if you allow me, I would like to talk about that. No, thank you. Just enumerate the changes. You shouldn't give a detailed analysis. We just won't have enough time for that. So we need to introduce amendments into the regulation and into the procedure to bring it into conformity, at least with the decisions of the Cassation and Administrative Court of the Cassation Court, which cancelled some of the decisions of the previous HQCJ, because even in 2018, as for that time, these provisions did not correspond to the provisions of the law on the judiciary and the status of judges. All right, thank you. And please let me give the floor to Yevhen Mezentsev. You're welcome. Good afternoon, Tetiana. Let me ask you the following, to follow up with the questions on property. We studied your declaration and we saw that you have got a certain stereotype in terms of how you feel your declaration. In 2018, your personal income was about 360,000 hryvnias. It was growing, thanks God. Lucky you are. And then next year it was 963,000. Actually, it was not next year, but in 2021. Over the last 6 years, in 6 or 7 declarations that we have studied, you don't have the section financial income. So you don't indicate that at the end of the reporting period you have some amount in your accounts which is about 50 subsistence minimums, and you don't indicate that you have any savings. Does it mean that you really spend everything you earn throughout the year? I don't have the data indicated in that section, since it was not a single time that at the end of the year I had an amount of money that would have to be declared. Since in my family I'm the only person with income, I don't take into account my mother, who gets the minimum pension, and the expenses are very high. The expenses were increasing from year to year for me. And my daughter is in the 11th form. She's a school leaver, and I'm really proud of her achievements in her studies. And her studies require quite an amount of money. And I live in the apartment which needs to be repaired because it has not been modernized for quite a period of time. It's not a new apartment. It's about 35 years. Was built about 35 years ago. So I'm doing the repairs from year to year. I think that's 963,000. If we deduce 20% of taxes, that's much lower. And over the recent reporting period, you didn't have any expenses exceeding the amount of 50 subsistence minimums. Does it mean that you're not buying anything, or you're not spending money on trips and travels, or you don't have one-time expenses that would be more than 130,000? No. Probably if my salary was paid was for 1 month was more than 130,000. But if you don't get such a high amount of money for a month, and you have a lot of daily issues to settle, so that's the way it is. Okay, thank you. Now further details are necessary. Your answer has been accepted. Concerning assessment made by the HQCJ members in terms of the candidates and judicial candidates and government judges, you know that some score is based on objective criteria, but there is also a discretionary part of it, which is based on the internal subjective opinion of the members of the commission. What do you think should be the correlation, the ratio of these two categories? The objective score and the discretionary score. 50-50, 75/25 to reduce this element of subjectivity and own discretion within the selection procedure. What would you think would be the right choice? Well, I think that 70/30, something like that. 70% should be objective score, while about 30%, probably I should rephrase it. It should all be at least reasoned, but some part is objective and the other part is more subjective and discretionary. And as far as the qualification assessment is concerned, I would like to draw your attention to the need for reasoning. I think that probably in the future, since we have Article 88 with its provisions, probably we should have the same provisions for the selection. If we compare the selection procedure and the qualification assessment procedure, or selection not to the two trial courts, but to the High Anti-Corruption Court, which is also a court of trial instance by its nature. So the selection rules there are somehow different. So I think this is a wrong approach. They should be the same. Thank you, Tetiana. Let me give the floor to my colleague, Tad.
Ms. Slutska, you say in your information note that your professional experience makes more than 19 years, and for 11 of them, I have been holding managerial positions in cassation instance courts. Now, that is what I concluded as well from reading your autobiography, that for the most part, your positions have been managerial in nature. Can you tell us a little bit more about what was involved, for example, in the last 7 or 8 years? You were head of the department supporting the deputy chairperson and secretary of the judicial chambers, head of the department for consideration of appeals, and provision of public information of the Secretariat of the Criminal Cassation Court. Now, what do those managerial positions consist of? What were your duties and responsibilities?
If we talk about my immediate responsibilities, if we look at the names of the positions, that would be to prepare a statement for the deputy head and the secretary of the judicial chamber, summarizing of our court practice, trying to identify the existing gaps and problems, and reporting on those gaps and problems to the superiors, and And since the title of my position is related to the organizational activities within the court, since I have the analytical skills, I also perform the functions related to the development of information letters, recommendations. I was ensuring the organization of different roundtable discussions.
All right, thank you. That gives me some indication of your level and contents of your experience. Let me move on, if I may, to your comment that you delivered lectures at the National School of Judges for trial and appellate instances. Can you tell me when you did that, in what years, and what the lectures consisted of?
It was between the years 2012 and 2011. 2018, I'm sorry. So in 2012, I had lectures pertaining to the implementation of the innovations in the Civil Procedure Code. Those lectures were dedicated to the issues of criminal punishment with regards to underage citizens. And also some of the lectures dealt with deals.
It struck me that with some of the experience that you've had in courts of high levels, that you yourself might have been interested in applying for a judicial appointment. Unless I missed something in your history, which I've studied, I don't see that you have applied for any judicial position. Is that correct? And if so, why have you not chosen that career path?
No, I've never participated in any selections to be appointed as a judge. I think the time will come. I think that I can be more useful if we look at current times. I can be more useful as a member of HQCJ. And then if I'm not appointed as a member of HQCJ, I will maybe reconsider my position. I cannot explain why I never wanted to be appointed as a judge. It was never my objective. I'm developing information letters, recommendations, explanations which were used across the territory of Ukraine, and I understood that I brought some benefit. Maybe that is why I never tried to become a trial judge or a judge of an appellate court, but I think life will show us.
All right. Now, in reviewing your biographical professional history, correct me if I'm wrong, there does not appear to be any experience that you have as a lawyer working in the courts or a private law firm. Have you ever yourself appeared as a lawyer for anyone in court? And do you have any experience with the presentation of cases and basically the work of a judge at the trial instance?
No, I don't have this experience of representing the interests of clients in courts, but I have the experience of working within courts. If you ask me whether I'm knowledgeable about how the judiciary works, then I am. So we can say that it's also some kind of experience, but I've never acted as a lawyer. I've never represented the interest of clients in courts. In 2011, I was appointed as scientific advisor at the High Specialized Court, and up until now, I'm occupying this public office. I'm a civil servant.
All right, thank you. I'm going to pass the questioning on to my colleague, Mr. Broekhuizen.
Thank you. Good afternoon, Ms. Slutska. I've looked at your question 8 in your motivation letter. In the motivation letter, there was a question, and it asked at your future vision of the judiciary. And a vision is something that you hope that will happen, and that where you give some outline how to accomplish that. Of course, you know what a vision is. And when answering this question, you refer, you don't say much, but you say, well, the procedures are not in order. Apparently, the procedures of the former HQCJ, they were incomplete. And let's say, implicitly referring to the principle of legality, which is a principle coming from Roman times, which says that you cannot be punished without a proper law. You say that those rules of the HQCJ should be amended into a proper form. And I'm sure you're right that that should happen. But the point is that it is not a vision, that is a recommendation, I would say. And I also want to put let's say, confront you with a rule which comes from a recommendation that has been accepted by the Committee of Ministers of the European Union about judges and judiciary, where I hope at a certain moment Ukraine will have to adhere to. And in this recommendation, which is accepted by the whole of Europe, and I will read it to you, it says, judges who are part of the society they serve cannot effectively administer justice without public confidence. They should inform themselves of society's expectations of the judicial system and of complaints about its functioning. Permanent mechanisms to obtain such feedback set up by councils for the judiciary or other independent authorities would contribute to this. So if I translate that, what it says is, if there is no confidence in the judiciary, then you don't have any judiciary, and there is no rule of law. And then, of course, if you don't have it in your country, you cannot be part of the European Union, because this is a very hard rule. Well, when I looked at your vision, reminding this rule, I thought that this is not the solution, what you write. What is the solution? What is your real vision?
Can I start answering? And thank you for the question. At the very beginning, in my introductory remarks, I mentioned my vision. So I told you about a judiciary that complies with the international norms and standards, because we have it only in theory that the judiciary must be within the system of the other three branches of the government. So I would say that the judiciary should guarantee stability in the society, legality within the society, and protection of the rights and freedoms of citizens. In what way can we achieve that? I think that it depends, among other things, on the activities of HQCJ, not just on the HQCJ, but on HQCJ among others. So I'm talking about quality selection. How can this be implemented? I do have a vision of that, of how it can be implemented and what kind of amendments must be introduced. So the previous HQCJ neglected some of the provisions of the law on the judiciary and the status of judges. And if they followed those provisions, we would have trust in the judiciary because people would see the motivations, the reasonings behind the decisions of HQCJ. If the decisions were published, for instance, we can look at PIC, and the PIC on their website publishes information with regards to their opinions, and I really like how their website looks like.
But may I interrupt you, Ms. Slutska? What I ask about is a vision, which means your ideas for the future of the judiciary. And I repeat myself, without public confidence, no judiciary. The position in Ukraine is, if I read all the reports, that only 20% of the people have trust in the judiciary. And the reason for that is, I read in all kinds of publications, not only the lack of judges, but also the amount of corruption in the judiciary and in the public offices in Ukraine. And and when you're part of HQCJ, you have to do everything to avoid that, and you have to start selecting people who start avoiding that. But in order to do that, you need to know what you're looking for, and therefore you need a vision. So I ask again, what is your vision on the future of the judiciary and how to accomplish that?
I think that the judiciary is capable of self-cleansing. If we have an efficient HCJ, because we are having an updated composition of HCJ, and I believe that the HQCJ, the new HQCJ on its level, will be preventing people with lack of integrity from getting into the system. So if we have all of that, it will enhance the level of trust in the judiciary. In addition, we also need to introduce, maybe not introduce, but we need to have the rule of law within the judiciary. Yes, so you mentioned that some of our judges still follow those rules from back of the Soviet era, but that's not applicable to all the courts. We need to see how the rule of law is implemented in practice, and judges should not be afraid to follow international documents, to use the international practice, the practice of the European courts, and they need to use this principle of the rule of law in practice. If you ask me, on many occasions in my explanations when I was developing them, I was writing that the decisions and the solutions to problems should always take into account the rule of law. We need to think about avoiding practical situations in which a person appears in a situation that is worse than it should be according to international agreements.
Okay. I understand where you're going.
But we need to work on that.
Thank you. Maybe I pass the floor to the chairman.
Thank you. Пані Тетяна, ви
Tatiana, in your motivational letter, you mentioned that you've witnessed several attempts to reform the judiciary in Ukraine.
які спроби були успішні?
Which of those attempts were successful and which weren't? If we talk about judicial reforms in a wider sense, then none of them have been completed. When I started working at the high specialized court, and the appearance of this high specialized court was the result of the judicial reform. What do you mean by saying the reforms were not completed? I think that we can say that a reform has been completed when we no longer need additional reforms. And who has a say in whether the reform has been completed or not? This society has a say in that. If they are dissatisfied with the existing judiciary, with access to justice, and the people's deputies must respond to the demands of the society and then continue the reforms. And how can we guarantee that this time the society will be satisfied with this reform? If we talk about guarantees, I think that there are some. I think that a significant role here will be played by the updated HQCJ and HCJ. At the moment, we have no questions with regards to HCJ because it was elected with the involvement of international experts. I'm not saying that the previous compositions of this body were elected using some incorrect methodology, but I believe that our people trust the international community more, the international experts more. And the same applies to HQCJ. I think a lot depends on HQCJ and HCJ. And if they fulfill their mandate in an efficient way, I think that the judiciary is capable of self-cleansing. I'm repeating that by implementing the mandate of these two bodies in an efficient way. And I cannot tell you that all the representatives of the judiciary are bad, that they don't follow the rule of law. We have some worthy people. We have representatives of the judiciary, and it's a pity that in several months some of them will have to retire because they are 65 years old. And I believe that some of these people are doing a lot for the practice for criminal justice, including their ability to analyze, the ability to show how one should act, both in life, professional life, and private life. So these people have great authority, and this authority is based on their professional knowledge. That is why I think that if there is an initiative not for these people to retire once they've reached the age of 65, I think it would be good for these people to continue working until they are able to do that. And we must prevent judges who lack integrity from being in this profession. And for this purpose, we can use the qualification assessment. We can consider the disciplinary complaints, because we cannot say that these people can efficiently perform their duties. And I know that there are many disciplinary complaints that have amassed at HCJ, and we need to have the disciplinary inspectors who will start their work. But once they will start working to their full capacity, I'm sure that people, judges without integrity, judges who are not professional, will not continue working within the judiciary.
Нової ВКС ви бачите?
What are the priorities that you see for the new HQCJ? Just enumerate them. 1, 2, 3. Thank you for the question. Could you please clarify what kind of priorities do you mean? First steps? No, I mean priorities. What should the priorities in the work of the new HQCJ be? Priority number 1, priority number 2, and priority number 3. The first priority should be to prevent selection or appointment of judges if they are completing qualification assessment, if these people don't have professional competence and integrity.
Тобто це принцип, я вибачаюсь.
I'm sorry for interrupting you. So you are talking about the presumption of non-integrity. Do I understand you correctly? I'm talking about presumption of lack of reasonable doubt. If during qualification assessment I have no reasonable doubt, I am a person who analyzes things, who analyzes facts. It is important for me. So if there's no reasonable doubt with regards to a candidate's integrity, then if we talk about the exams, everything will be more or less obvious. But if we talk about the qualification assessment and the practical assignment, then we will analyze the results, we will score those assignments, then we will motivate the score, and we will give the participants an opportunity to appeal the results. Currently, it's not included in the regulations, so they can appeal the results. The results must be motivated, well-reasoned. They must confirm some facts. Yes, that's clear. So, to summarize, we must follow the procedures. Yes, I agree with you, because it's hard to disagree with what you're saying. So, within our commission, we have representatives of the United States of America and Canada. So, if we summarize the experience of these countries, then there you can be appointed as a judge if you are a mature person, if you have already accomplished something within the profession. So it's a partner from a law firm, let's say, or a person who's been a prosecutor for many years. So this is what happens most often. A judge is somebody who is an accomplished, seasoned professional. So this is the approach that these countries use.
В українському контексті ви вважаєте, що
If we look at the Ukrainian context, what do you think? Do we lack these seasoned, more mature professionals
якби битих професіоналів,
who have seen a lot in their careers, or
свіжі, енергійні,
on the contrary, do we need young, energetic,
ваш погляд, в
a
нашому
different
контексті,
type of professional?
як би ви спрямували цю
So let's discuss the Ukrainian context. How would you direct the work of HQCJ in this respect?
If we consider this issue from this point of view, we really need experienced people, but these should be the people who are ready for changes and for challenges. As it has been mentioned, they should not be afraid of legislative amendments, introduction of the institutions that are not characteristic for us, because quite often, even young people, in spite of their young age, we can see the tendency not to be willing to change anything because they are they are not aware of availability of some institutions. They don't want to work towards improvements, and since they understand that introduction of a certain institution will actually be good for the state, but they are not willing to change anything. So I like people, and by the way, we do have such people who are ready for changes. You know, our impression generally is that if a person studied in the Soviet period or was brought up in the Soviet period, these people are not willing to change anything. But even, we have introduced this Canadian experience of pre-trial report. And even before we had the law on probation adopted, we had some changes in that field, and these amendments were introduced by judges who were about 35 then because they were ready for changes. They knew that it would be for the better, in spite of the fact that they were living in the period of the Soviet Union. Okay, you've gone too far, I would say. I'm going to lose your idea. So, still, experience over use or use over experience? I don't think that we can generally judge by this factor only. Young people can be also professional and ready to learn, able to learn, while experienced people can be left without any development or may develop further on. We are in the process of reform of the judiciary, not just the court system, but legal system. But let me not be radical in this respect. Of course, if we mean young people by just graduates of universities, I don't think that this would be wrong. They should still have some experience. But I don't know whether we should have any limitations, like that only a person after 50 can hold a certain position. No, I don't mean restrictions or limitations. Just as I imagine the work of the HQCJ, it seems to me that at some point of time when the HQCJ reaches the issue of selecting new judges, the HQCJ will be having a kind of an advocacy campaign. It will be inviting candidates to participate in the selection for the judicial positions. And as I assume, the HQCJ will still make a kind of a profile, a vision of whom they're going to invite to participate in the selection. Because 2,500 positions, that's quite a lot. And these people should be found somewhere. But it seems to me that the HQCJ will be encouraging a certain type or a certain category of people following some criteria. That's why I'm asking you this question. Maybe one of the criteria will be preferable. That's why I'm asking this. But, okay, thank you. And do we have any further questions?
Не вийшло в нас з вами повноцінної дискусії щодо мови.
So we failed to have a full-fledged discussion about use and experience. But nevertheless, our interview is about to be over, Tetiana.
І на завершення, будь ласка,
And to conclude, we would ask you to sum it all up. Maybe you want to focus on something, to stress something at the end of the interview. You're welcome. Well, thank you. Thank you for having selected me to this list of 64 candidates, and I wish the commissioners to be wise. And as Robert said during one of the interviews, I want you to never be ashamed of your selection. Thank you.
дякуємо вам, пані Тетяна. На цьому
Thank you, Tetiana. So the interview is over. Good luck, stay safe, and goodbye. Thank you. Goodbye.